Hello, my name is Jessica Drake, Vice President of Strategic Applications International. I will be presenting the Sovereignty module written in partnership with SAI consultant Eric Rodriguez, a specialist in Native American tribal affairs. Today we will cover how tribal nations can have thriving law enforcement agencies, practices, and partnerships while retaining their sovereignty. This module will provide a basic understanding of sovereignty, including a brief history, why sovereignty is important to tribes, and it is designed to give an understanding of how sovereignty can be used to administer strong law enforcement by building capacity through thoughtful regulations and tribal law. Additionally, viewers will learn the basics about a limited waiver of sovereign immunity, which can be beneficial to tribal and non-tribal law enforcement in order to cultivate tribal and state partnerships to police tribal lands and the surrounding areas. Please take a moment to read the cartoon about sovereignty on the next 2 slides, and I will meet you back again on slide 5. Sovereignty is a complex issue in tribal communities where United States laws and policies overlap with tribes' right to govern themselves. Over a series of court cases throughout the years, the U.S. Supreme Court found that Native American nations had the full legal right to manage their own affairs, govern themselves internally, and engage in legal and political relationships with the federal government and its subdivisions. As you begin this module, it is important to understand that prior to the United States of America, tribal governments existed and were self-managed. Tribes enacted treaties with foreign countries, held their own culture-specific judiciary system, and managed their own lands. Today, in an effort to repeal old mistakes and poor policy, the federal government has established a number of laws to strengthen Native Americans' ability to self-govern, retaining their long-held sovereignty. Now we will hear from Olin Jones, former Director of the Native American Affairs to the Office of the Attorney General in California from 2000 until his retirement in 2017. Mr. Jones is a member of the Chickasaw Nation of Oklahoma. He began his law enforcement career in 1974, working in local law enforcement until 1989. And is a graduate of Yuba College and Minot State University in Minot, North Dakota. He has spent the last 2 decades working closely with Native American tribes on crime prevention issues and improved access to health and welfare resources. He is also the 1999 recipient of the Vision of Hope Award for outstanding contributions in violence prevention.
I'm Jessica Drake, and this is the PL-280 training module on sovereignty. I'm here with Olin Jones, Director of the California Attorney General's Office of Native American Affairs. Thanks so much for joining me, Mr. Jones, and for giving us your expertise on this subject matter.
Thank you, Jessica. It's a pleasure to be here.
So first, before we get started on the questions, I know that you've worked in the community of Native American affairs for some time. Could you give us a little bit of information about your background?
Certainly, be happy to. I began my experience in 1973. I know that dates me. I'm getting up there a little bit, but I began local law enforcement in 1973 and worked in that capacity until about 1989 when I came to the state and did various types of jobs at And then in 2000, I was appointed by former Attorney General Bill Lockyer to this position that I have now, and I've been retained by all of the Attorney Generals since that time. I'm now serving my fourth Attorney General, and been in the position of Director of the Office of Native American Affairs for 17 years. And during the last 17 years, one of the most challenging aspects to my position has been to address jurisdictional issues related to Public Law 280. As you know, California is one of those mandatory Public Law 280 states. So, in addition to working with California's tribes, I also have the honor of working with California sheriffs and district attorneys who are primarily charged with providing public safety and justice services to the tribes in California.
Wonderful, thank you. What an incredible wealth of experience. I consider us very lucky to have you talking to us today. So my first question speaks into sovereignty. Sovereignty can be widely interpreted in that it has many different aspects depending on the subject. In a PL 280 state, how would you define sovereignty and its importance?
Well, specifically addressing the PL 280 aspect of sovereignty, in my estimation, one of the most powerful and pure statements of sovereignty that a tribe can make is to exercise its preference for how public safety and justice services are provided to the tribe and their constituents and all of the land that they have under their purview. And that may involve, those expressions of sovereignty in the area of justice may involve the establishment of a tribal police department, a tribal court, and even in those counties where tribes are satisfied with the services they receive by the county sheriff under Public Law 280, they may feel like they want those who provide public safety services to be more accountable to the tribal council and the tribe. So in those instances, they may want to create their own arm of justice for the tribe. A number of years ago, we took a survey in the Office of the Tribes of California, and the response was very revealing. There were a number of tribes that were satisfied with the level of safety services they were receiving from the county sheriffs. A number of tribes were not happy with the services they were receiving, that did not have the resources to create their own tribal police departments or their own tribal courts. And then there were a third category of respondents that wanted to create their own tribal police departments, their own courts, and proceeded to do so. So out of the 110 federally recognized tribes in California, approximately 26 of them have created tribal police departments. And a number of those 26 tribal police departments have also taken the exigent step of getting a federal deputation that's offered by the Bureau of Indian Affairs Office of Justice Services. It's called the Special Law Enforcement Commission. And that provides the commissioned officer with federal peace officer authority. And having that level of jurisdictional authority provides that officer with a commission accessibility to criminal history databases that may not be available to a tribal police officer that does not have that level of authority. So it's a
Can I ask you a question about that before we move on?
Sure.
Is that different than when a sheriff's department cross-deputizes? And if so, can you explain that a little more?
Yes. It's California, the sheriffs in each county do have the authority to enter into deputation agreements with tribal police departments. And in those instances where tribal police officers are deputized, they become like a level 1 reserve officer, and they have the full authority of a state peace officer. They have access to the county's jails, correctional facilities. They can file cases with the district attorney. But they are, in essence, those tribal police officers that are deputized are, in essence, become employees of the sheriff's department when they're enforcing state law. So they are, in those instances, under the direction of the county sheriff, not the tribal chief of police at that time. So there is some distinctions that are obvious. And if you compare that deputation agreement situation to the tribal police officer with a special law enforcement commission, there's no state peace officer authority vested in the special commission by the BIA-OJS. They are considered to be federal peace officers when they're enforcing federal law. So there's a difference there.
We speak a lot during our module about the difference between federal side and state side. So I really appreciate your explanation because I think it helps our listeners and those who are interested in the subject matter differentiate between the access among police departments in their skill set. Can you explain or provide an example where a tribe may have waived their sovereign immunity to better improve a partnership or business holding within the tribe?
So that comes to mind is in 2000, gaming became legal. Tribal gaming became legal in California, and the legalized gaming between the tribe and the state of California is accomplished through a document called a compact. And some of the language in the compact recognizes that there will be instances where non-tribal visitors will be coming onto Indian land. And as we all know, tribes are sovereign and immune from state court in areas of civil liability. So in order for those patrons to be safe and covered by some type of liability clause when they're on Indian lands, that's why that language was created in the compact, to allow what's called a waiver of sovereign immunity. So in that instance, the cap on that liability is $5 million. And it's not giving up sovereignty. In that instance, a waiver of sovereign immunity has been immensely successful for the tribes because they've exposed their liability up to a cap of $5 million in order to get the ability to have successful gaming operations in place.
When it comes to tribe growth and partnership with local community law enforcement, such as the town outside of a reservation, what are a few things you feel are best practices within those partnerships? An example might be some form of limited waiver of immunity, some type of memorandum of understanding, a shared resource like a 911 service. What is something that you could identify as a few best practices or good things to pursue in this space?
Well, I can think of some real-world examples in those instances. And for the sake of our conversation, let's say that a tribe is in a position where they do not want to have the tribal police department, and they're working with the local sheriff to help make sure that their lands and any of their economic development opportunities they have in place are being protected by the sheriff's department. And I guess I should say their assets are being protected by the sheriff's department.
Absolutely.
So in an instance like that, it may be good for the tribe to ask the sheriff if there's a need, if they need to have additional coverage over and above what they would get under PL 280, they might want to enter into some type of a contractual agreement where they may pay to the sheriff's department for an amount that would be equal to the salary of a deputy, and then have a deputy assigned to that reservation. That does happen in California from time to time. Also, there may be issues with sheriff's departments patrolling, just regular patrol services. So some tribes in California will be interested in advancing an ingress and egress type of policy in non-emergency situations. In other words, if the sheriff's department wants to do regular patrols on an Indian reservation, the tribal constituents may wish to have a policy for how that occurs in place, which is well within their rights as a sovereign nation to undertake that type of an agreement. Unless there's an emergency situation, then the sheriff doesn't have the time to check with the front gate or to observe those type of observations, because he has to respond to an emergency situation or to save a life or something of this nature.
What do you feel are the benefits of tribes/communities in the state when a council and a local law enforcement agency enter into an agreement that allows for cross-deputization, or if this applies a limited waiver of liability? Do you think there are benefits in this space, and what would they be? And to that point, it might be if you were speaking with the tribe and helping them develop MOUs or a contract, what would you say the advantages to this growth is?
Any public safety agency, we have unlimited liability caps in California, whereas some states, and I'm thinking of maybe, well, I won't name a state, but some states do have caps on the police officer liability.
Yeah.
But in California, we do not. So that's one of the biggest obstacles that tribal governments might have with creating a tribal police department. If they wanted to have the same type of authority and jurisdictional power that a state peace officer would have, they would have to be able to match the same type of liability coverage. Have a situation where if you were on state lands, you would have a different liability than if you were on Indian lands, and it would send a bad message if the Indian land liability was much lower. The cap was much lower, so it would be really imbalanced. If you have a situation like that, it sends a message to the public that your life would be worth less on an Indian reservation than it would be if it was on state public land. So that's why the liability coverage needs to be the same. But in that instance, you're asking tribal government then to waive their sovereign immunity in an unlimited number. So that's one of the impediments in California to having a tribal police agency get state peace officer authority, because they have to match that liability coverage. Well, let me step back in California history to some things that happened probably back in 2001, 2002. During that time, there were a number of tribes in California that wanted to pursue a legislative bill that would provide state peace officer authority to tribal police officers. And and they brought their interest to the California Attorney General's office and to the legislature. And they began the process of developing a bill. And there was a state legislator at that time. His name is Richard Alarcon. And the draft bill was SB 911. And we entered into some dialogue with the state's law enforcement community, and there was some significant pushback from the state's law enforcement community over several very valid issues that they have. And as I recall, the state law enforcement community, which is very protective of their industry, understandably, they were concerned about the language in the bill that dealt with tribal police officer training and their liability coverage in view of the fact that tribes are sovereign and immune from state court redress. As you know, police agencies are frequently suits are frequently brought against police agencies for alleged abuse of authority or brutality or something of this nature. So they wanted to make sure that if the tribal police officers that were pursuing this state peace officer authority had similar, if not the very same, coverage that they are charged with maintaining. Another issue that they had was the tribal police officers' accessibility to California's criminal history databases. And so those three issues were paramount in the bill. And there was some significant discussion and contentiousness over the liability issue. So I believe the bill was pulled from committee in 2002. But it was pulled, and the language actually was very, very good. And the bill was pulled over a disagreement over liability, and the tribes at that time wanted to take the figure of $5 million as a liability cap. Their exposure was going to be set at $5 million, and they were using the scenario of the gaming compacts and applying it to the tribal police department's liability exposure. And then the law enforcement community at that time came back and said, well, no, that's not going to work. We don't have a cap. And if you're going to be enforcing state laws, then you have to have the same liability coverage that we have. And that is unlimited. And that became so offensive to the tribes that they could not live with that. And the tribes argued. They said, well, you have all of this liability coverage, which is unlimited, but we only have limited land that we're serving. Sometimes our reservations or rancherias are very small. So why should we have the same level of coverage that you have when we're only covering this small amount of land? And then, of course, the law enforcement community came back and said, well, that doesn't work because the liability limit should be the same because the constituents are going to be state constituents coming onto Indian lands. And that's where they used that example that I shared a few minutes ago of, in that scenario that you're suggesting, tribes, the person's life would be worth less. That would send a message that their life would be worth less on an Indian reservation than it would be on public lands if there's a difference in liability exposure.
Insight has been tremendous, and you've spoken into so many important topics with regard to what is PL 280, but what it really means with law enforcement on both reservations, state policing, federal policing. And so I thank you so much for your time with this. Before we close, would you have anything else you'd like to speak about or share?
For all of the attorney generals since Bill Lockyer, and I'll name them, Bill Lockyer and Attorney General Brown, who's now Governor Brown, Attorney General Kamala D. Harris, and our current Attorney General, Javier Becerra, have kept this office in place. We're at the executive level in the organization, and they were all and are deeply committed to tribal justice issues and regularly communicate. The AG regularly communicates with this office, and I think you're going to see great things in the future with our current Attorney General in relation to tribal justice.
Well, thank you for mentioning that. And I think that I, unfortunately, in this interview might have left out the strong role that the Attorney General's office plays in any PL 280 state. To the role of the AG's office in this space in any way, please do.
I will do that, and honestly, that's why this office was created in March of 2000, was to provide an open door to California's tribal governments in regards to their justice needs, their justice goals, and we want the tribes in California to be a cooperative partner in how they view and how they frame justice.
Tribal nations have inherent powers as sovereign nations that existed before the discovery of the Americas. The following United States Supreme Court cases and federal laws reduced inherent powers from tribal governments. Some limitations on inherent tribal sovereignty include 1817 Indian Country Crimes Act. The ICCA provided federal punishment mechanisms for crimes committed by non-Indians in Indian country. Also in 1817, Assimilation Crimes Act, which provided federal prosecution to fill gaps for federal criminal laws by using state criminal laws and using the state law in federal proceedings. 1885, Major Crimes Act and Ex parte Crow Dog case are directly correlated. Congress passed the Major Crimes Act in reaction to the Supreme Court's decision in Ex parte Crow Dog, which held that the federal government had no jurisdiction over a tribal member who killed another tribal member within Indian country. Congress was upset because Crow Dog was not punished harshly enough for his crimes according to their standards, although the tribe had used retributive punishment, which was their common practice. Congress then passed the Major Crimes Act in order to have jurisdiction over the cases that involved a major crime, in order to provide what Congress believed to be adequate punishment. In 1886, United States v. Kagama, the Supreme Court upheld the Major Crimes Act as constitutional. Skipping ahead many years to 1953, Congress passed Public Law 83-280. Congress passed PL 280 without the consent of tribes and originally granted 5 states civil and criminal concurrent jurisdiction. Some states did not like the addition of jurisdiction on reservations, but because the states were not given additional funding to provide law enforcement on reservations. You can learn more about this by engaging in our training, What is PL 280? In 1978, the Supreme Court in Oliphant v. Suquamish Indian Tribe ruled that the tribe did not have jurisdiction over non-Indians. Since that time, though, there has been some restoration of tribal sovereignty that released restrictions on inherent powers of tribes. You can see that in 2010, the Tribal Law and Order Act, which was passed, as well as in 2013, the reauthorization of the Violence Against Women Act. Tribal sovereign immunity exists outside the constitutional framework of the United States. Tribal sovereign immunity is an inherent power that barred suit against the tribal government. Because tribal governments are not part of the constitutional framework of the United States, there is no constitutional text where an origin of tribal sovereign immunity can be traced. Instead, federal governments have developed what is known today as the Tribal Sovereign Immunity Doctrine. The federal courts have articulated the reason that the doctrine of tribal sovereign immunity exists is because immunity is thought necessary to promote the federal policies of tribal self-determination, economic development, and cultural autonomy, as articulated by the Eighth Circuit Court of Appeals. According to the Bureau of Justice Affairs, tribal sovereignty is the right of self-governance. It ensures that the decisions about tribes' property and citizens are made with their participation and consent. This bears great importance to Native Americans who saw the erosion of their rights as the United States was populated by Eastern colonists over a period of 400 years. Once a force great and powerful, colonization depleted the Native American population and subsequent power, creating a loss of culture, law, and rights for tribes across the nation. Sovereignty and the right to govern oneself is at the core of any civilization. To retain this is at the utmost importance for many tribal leaders across the nation. Tribes possess the right to perform their own governments, to make and enforce laws, both civil and criminal, to tax, to establish and determine membership, i.e. tribal citizenship, to license and regulate activities within their jurisdiction, to zone, and to exclude persons from tribal lands. Limitations on inherent tribal powers of self-government are few, but do include the same limitations applicable to states, i.e. neither tribes nor states have the power to make war, engage in foreign relations, or print and issue currency. Through their tribal governments, tribal members generally define conditions of membership, regulate domestic relations of members, prescribe rules of inheritance for reservation property not in trust status, levy taxes, regulate property under the tribal jurisdiction, control the conduct of members by tribal ordinances, and administer justice. They also continue to utilize their traditional systems of self-government whenever and wherever possible. With sovereignty being so important, why then would a tribe enter into a condition where they are potentially sacrificing sovereignty? The answer has to do with the competitive nature of business and standard operating procedures of modern times. Consider, if you will, a Native American casino. As a business, it needs to not only to support its employees and sovereign society, but in addition, as a business, it must prepare for customer issues and complaints. Waiving sovereign immunity to extend standard business practices to tribal organizations is a way for the tribe to assert its business acumen, its commonality with non-tribal businesses, and to show that it cares for its customers and employees, not only tribal self-interest. Many non-tribal organizations entering into contracts with tribal boards or councils see the waiver of sovereign immunity as a major step in trust building between the two organizations as they enter into shared liability as part of their agreement. With the doctrine of tribal sovereign immunity, there can be challenges that come, such as negotiations of cross-deputization agreements between tribal and state governments. As published by Duana Champage and Carol Goldberg in Captured Justice, Native Nations and Public Law 280, there are solutions for how to work within PL 280 states and have positive outcomes in regards to law enforcement. When negotiating between tribal and state governments, for example, cross-deputization agreements, there is often emphasis on tribal sovereign immunity. Only a tribal government or Congress can waive tribal sovereign immunity. If there exists obligation under the cross-deputization agreement to share liability, unless the tribal government has signed a limited waiver of sovereign immunity, then the suit will be barred in tribal court. This creates tension between the tribal and state governments because of resource limitations and a variety of other concerns. However, there do exist cross-deputization agreements throughout the U.S., one example of which is White Earth Band, which requires the tribe to waive sovereign immunity against suits from individuals against a tribal officer who is exercising tribal law enforcement authority. Take a moment to review the diagram and note how cross-deputization can work within a state/tribal partnership. Working with PL 280 laws is possible, and there are multiple solutions to collaborative law enforcement in the field. An effective government is the ability to work with other governments and its people. A waiver of limited sovereign immunity can allow for trust between citizens and the police department, noting that they will be heard in court should an incident occur. Additionally, waivers of tribal sovereign immunity can allow for easier negotiations in law enforcement agreements because liability can be handled in both tribal and state court. Solutions to the barrier of sovereignty can often be resolved through definitive language around what tort claims a tribe will be liable for and what they will not or cannot be liable for. In turn, the state or partnering law enforcement agency needs to understand that most tribes cannot support or assume multi-million-dollar claims, thereby clearly defining what the tribe bears responsibility for when and if suit were brought will create an insightful policy agreement. There are a large number of examples to anyone considering entering into a cross-deputization agreement or the like with a differing agency. What is important to remember is that they can be nuanced and crafted in such a way that they represent all parties' interests in very specific and insightful ways, such as the Oneida tribe in Green Bay. They entered into an agreement with the city of Green Bay that they would enforce any arbitration brought forward under their deputization agreement. Thereby, should one of their department's deputies be sued for injury or some other type of infractions, the Oneida have agreed to enforce the court ruling. Such a decision brought confidence to the county sheriff's department that the Oneida deputies were committed to following the sheriff's department rules while acting as an agent of that law enforcement arm. Working within PL 280 is a workable solution. An effective government is the ability to work with other governments, policies, and its people. A waiver of limited sovereign immunity can allow trust from citizens in the police department that their voice will be heard in court, and also allowing easier negotiations in law enforcement agreements because liability can be handled in both state and tribal court. We hope you will take the time to explore the resources provided both in this training and at www.cops.usdoj.gov to learn more about how you might support your organization in future partnerships.